Okay, I think we can get started now. I just had to make sure that we had the live feed because we're all together because of two words in Rule 21.1 of the Uniform Superior Court rules. We need to have a public hearing about the request that plaintiffs have made. But let me figure out if we've got all the right people here. I am here to be talking about case 2021cv351134, which is Todd Baldree and some other folks suing Turnstone Group and some other LLCs, and then Chip Johnson. Who do we have for plaintiffs on the call?
Your Honor, my name is Kate Baronato here for plaintiffs from the Robbins firm.
Hello, Ms. Baronato. Thank you for being here.
Of course.
And who is here for Turnstone and others?
Good morning, Your Honor. Jamil Favors on behalf of defendants from Crumlin and Horse.
Hello, Mr. Favors. Thanks for joining us. And Mr. Favors, you represent all the defendants in the same way that Ms. Baronato represents all the plaintiffs?
Yes, Your Honor.
Okay, then we have everyone we need. Let me tell you what I think is going on, and then I'm going to let Ms. Baronato take it from there. But of course, Mr. Favors, I will give you a chance to add whatever you want to add. So plaintiffs are suing defendants about distributions from some real estate partnership, and really the nature of the lawsuit's not so critical here. The reason why we're together this morning is that plaintiffs have filed a redacted complaint. There are parts of it that are missing from the public filing, and there is a motion to keep those redacted portions under seal and to file with the clerk a sealed, unredacted version of the overall complaint. Nothing peculiar about that, but the uniform rules do require that I have an open and public hearing before ruling on what I understand is an unopposed motion. So I know for both of you, this isn't going to be a lot of heavy lifting, but we are where we need to be per the rules and appellate court precedent. I need to make a few findings. I won't do it here. I'll likely be letting Ms. Baronato submit a proposed order that has those findings. But I've taken the time to review the exhibit that Ms. Baronato, your team got to Ms. Niles, that is the unredacted version, but it helpfully highlights the parts that are redacted. So I didn't have to hold the 200 and something page document side by side. This just is the excerpts of that which is redacted. And I guess as it would help me understand what is so sensitive about what is being redacted. I appreciate there's a confidentiality clause in the severance agreement. I've looked through the severance agreement. I'm not someone who frequently writes or critiques or receives severance agreements. So there may be things in there that are really earth-shattering, but they didn't grab me. And so I need to understand why it is, even though it's an unopposed motion, your clients believe that their privacy interests outweigh the public's right to know some basic things. Like one of the things that you're seeking to have redacted is in the prayers for relief, a line about specific performance. And I don't know if it's the existence of this agreement that is so sensitive or the contents or both. So I'm going to turn it over to you to walk me through that. I'm not ill disposed to sealing things. I just need to feel comfortable that we aren't being over inclusive in the things that we're trying to seal, if that makes sense.
That makes sense, Your Honor. And just to clarify, so we've spoken with our client, Mr. Flom, who is our party, who is a party to that agreement. And frankly, if defendants are okay with it, and I'll let Mr. Favors speak to that, we are fine with unsealing the severance agreement. We, out of an abundance of caution, redacted it. We didn't want to be in violation of the agreement itself. The confidentiality provision is pretty broad. Not only is the fact of the agreement confidential under those terms, all the terms of the agreement are confidential.
Okay, well, that helps me better understand it, that the fact of the agreement was something that was meant to be maintained in confidence between the parties, because that's where I was feeling a little pushback as I read it. And I say pushback from me. I've not heard anything from the defense. Keeping Exhibit C under seal to me seems like and any excerpts from it that were included in the complaint seems like the natural dividing line. But the existence of the agreement and references to it seem to me a little more problematic. So I just want to make sure we struck the right balance as we navigated this. But again, I'm not making a big deal out of this. It's just if ultimately this doesn't resolve itself and there's a trial, I assume things that are currently under seal would need to be unsealed and handed around in court and shared with the jurors, et cetera.
Sure. And I think, and again, I'll let Mr. Favors speak to this, but there are some negotiated terms in the agreement that perhaps the Turnstone defendants would prefer not to be public. To the extent they need to negotiate such agreements in the future, they might find themselves at a disadvantage, but they may not feel that way. So, but we wanted, out of an abundance of caution, to not breach the agreement by filing this complaint, and would be fine, I think, with a total unsealing of the document, or we could unseal the portions at issue anyway. But I'll let Mr. Favors speak to this.
So, Mr. Favors, I'm now getting a better sense that this was actually a cautionary step taken by plaintiffs. It wasn't something that they were insisting on, but they were wanting to abide by the terms of this agreement and not get something out in the open that would lead to other expensive litigation between your clients and Ms. Baronato's clients. So why don't you share with me your perspective on what, if anything, ought to remain under seal as we move forward?
Thank you, Your Honor. I won't present to know what the parties were thinking when they penned the agreement at the time. But what we will say is that, when we saw the motion to seal, it really caught us off guard. But it makes sense, right? It was a precautionary tale to ensure that, any other further litigation wouldn't go forward at a later date. We've spoken to our clients. Our clients has no issue with the agreement going forward. So that's why we didn't file anything in opposition. So, we appreciate opposing counsel doing their part, but, we stand neutral. And if it would like to be in the open, that's perfectly fine.
So, Ms. Baronato, what I'm hearing then is that it may be that you and Mr. Favors want to talk offline so that your client gets some commitment that he's protected from any adverse claim by making the entire complaint a public document. But I'm hearing Mr. Favors say that his clients don't have any objection to anything and everything you included in the complaint, to include Exhibit C, being made public, which is the default and the preference, of course, the public policy preference as to how we ought to proceed with civil litigation. But I'm mindful of your clients wanting to be cautious about how they move forward with that. So what I'm now hearing from both sides, if I distill it, is, you know what, we filed it under seal out of an abundance of caution, but we plaintiffs don't have any issue with nothing remaining sealed. And I think I heard Mr. Favors say the same thing, but I don't know what, Ms. Baronato, you'd want to get in writing by way of an email or something, because while this is a public hearing right now, there is no court report or anything like that. Before you withdraw your motion to seal and file not under seal the unredacted version of the complaint, because it sounds like that's the way we're heading.
I agree with you, Your Honor.
Okay.
Same here.
Okay. So what if we just say by Wednesday? I want to give you enough time. It's Friday, Friday the 13th. If I just say by Wednesday, you would get filed a withdrawal of your motion and a filing of the unredacted complaint unless something comes up and we need to revisit what we were talking about today. Does that give you enough time, Ms. Bernardo, to just do a little due diligence with Mr. Favors and get whatever assurances you would want from Mr. Favors' side that there will be no blowback if the unredacted version of the complaint, including exhibits, is filed?
That gives us plenty of time. Thank you, Your Honor.
Okay. Well, since I have you both here, there's a scheduling issue we could talk about. I've seen now that Mr. Favors and his clients have answered, and they answered simultaneously with a motion to dismiss. It's only a few days old now, so there's not a reply due yet. But I'm wondering if the two sides agree that there's an automatic stay of discovery. What I typically do, just because dockets are big here in Fulton, is ask both sides if they are comfortable with me entering an order that stays discovery until I rule on the motion to dismiss. Because of course, if I grant it, it would be wasteful for anyone to engage in any discovery. If I deny it, we would just have the discovery clock start around the time that the order is entered. We always hope to get the order entered in plenty of time, but hopes are sometimes dashed with crowded dockets. How does that work for you, Ms. Bernardo, if I were to enter an order, or do you want time? I don't mean to rush things. I just, as I was looking at the docket before our session, thought, hey, let's bring this up. You may review the motion to dismiss and either get the sense that all we need to do is tweak some language in our complaint and it's gone, in which case you may not want to delay discovery, or you may think that it's not going to succeed anyway, and you want to push forward with discovery because your clients haven't received distributions in so many months and they're anxious to move along.
Your Honor, I haven't spoken to my clients yet about the issue of, the stay, but I imagine that would be fine, but I can't say for certain, having not spoken to my clients about the.
Okay. Well, why don't you check with them, and maybe by Wednesday, you could let Ms. Niles know what's happening with the ceiling and your client's perspective on having the stay run until I rule on the motion to dismiss. Mr. Favors, does that work for you as well? Obviously, you need to check with your clients too, but if we were to freeze everything, other than this issue of sealing and unsealing, if we were to freeze everything while we litigate your motion to dismiss?
Yes, Your Honor. Honestly, we spoke to our clients and we were operating under the assumption of OCGA 911-12J, and that we wouldn't have to, discovery wouldn't, our responses wouldn't be due until 1 week after you responded anyway. So, we would appreciate, Your Honor, if Your Honor entered a motion, entered an order that would solidify that with the court.
Sure. So Jay gives everyone 90 days. Well, it gives me 90 days. You're stuck for 90 days by operation of law, unless I were to intervene saying, I skimmed this motion to dismiss. It's so patently frivolous. I'm not going to stay discovery. I've never done that. I guess it could happen, but I tend not to look at the motion to dismiss until I've got a reply. So I've got both sides. But what I try to do in every situation, unless we were dealing with look, we're trying to take someone off life support and it's literally life or death, is that I ask the sides for that flexibility because it helps you all plan as well. You're not worrying okay, it's day 89. Should I shoot out some interrogatories? The trigger for discovery beginning or a stay being lifted would be the entry of my order and not 90 days. So Why don't you check with your clients as well, Mr. Favors? But it sounds like you don't oppose that idea. And Ms. Baronato, you just haven't had a chance to check with your clients, but see what they say. It's not going to hurt my feelings either way. I just find that it flows more smoothly for the parties if the discovery is tied to the entry of the order rather than the 90 days. But we can work with it either way.
Thank you for that clarification, Your Honor.
Yeah,
Sure.
Thank you.
All right. So Ms. Baronato, anything else on behalf of your clients?
I don't think so. I think that's all, and we'll put the Wednesday deadline on our calendars and get back to you all shortly.
Great. Mr. Favors, anything else for your clients?
No, sir, Your Honor.
All right. Both of you, thank you for zooming in. Have a great Friday. And Ms. Niles will be looking for emails from the two of you no later than close of business Wednesday. If something comes up, hey, my clients are all in France doing real estate things over there, let her know if you need a little more time. But hopefully with the marvels of internet and whatnot, you'll be able to connect with the people you need to connect with between now and then.